Hi, everyone. Thank you for joining me today. My name is Holly Mullin. I am the managing partner at Sterling Law Offices. I am excited to talk to you today about something that I'm very passionate about, which is mediation in a divorce setting. So, mediation, I think, is actually often confused by my clients when I discuss what that might look like, what the process entails when we use mediation. So I thought it would be a good conversation topic for us to kind of go through the different types of mediation in a divorce and the different timing that we might explore those mediation processes. So first, let's just start with a bit of a definition of mediation. So mediation is when two parties agree to engage a neutral facilitator to help them negotiate an outcome. So if there's a dispute, you're picking one neutral person as a mediator to try and help you and the other person reach an agreement so that you can avoid the timeline and the costs and the expense of a litigated process and the uncertainty of going to court. Because in mediation, you aren't forced to an outcome, right? This isn't like Judge Judy, where you each present your arguments and then the arbitrator or the judge makes a decision for you and imposes an outcome. That's not mediation. So arbitration, that person is going to impose or make a decision for the outcome or the solution. Mediation, the parties themselves own the outcome. They are the ones making the decision. Huge, important difference there. So mediation is private. So you're not airing anything out in a courtroom. It's efficient. Both parties are coming to the table looking to, reach an agreement together. Just some background on exactly what we're talking about here when we discuss the mediation process. So mediators are often attorneys, but they don't have to be. So I'm an attorney mediator. I actually was certified in mediation before I graduated law school. I did the certification seminar through Marquette. And so I came out of law school a certified mediator, but there are non-attorney mediators out there. There are social workers who serve as mediators. There are financial experts that serve as mediators. So it's really important that you choose a mediator that has the skill set that you're looking for, right? You wouldn't want to be bringing in a social worker mediator to do like a complex financial case. So just know there's some differences there. I would say in whatever capacity that person has specialty in, they will have a solid amount of training in dispute resolution. The attorneys at Sterling that do mediation have all gone through several hours of training in order to be prepared to mediate a divorce case. The goal is, for the parties to reach an outcome at the end of mediation. And mediation can sometimes take a couple hours in a single session. And sometimes you have multiple sessions that span over the course of a few months. So let's talk about the types, right? So now that we know what mediation is. So type of mediation, one might be the custody and placement mediation that is ordered by the court, right? So let's say we have a divorce case where mom and dad cannot agree on the terms of custody and placement of the children. So meaning who gets to make the decisions for the kids and what the placement schedule will be. It's a rule in Wisconsin that if you can't reach an agreement about the kids specifically, the parties must attend mediation. So in this setting, I'm talking about county specific mediation, court ordered, and that's usually done with a social worker. Not always, sometimes it's an attorney mediator, but oftentimes they'll use social workers who are specially trained to help parents resolve issues related to their children. Now, when this is done, when the court orders parties to participate in mediation for custody and placement specifically, that is done actually without their attorneys. So if mom and dad both have attorneys in the divorce, those attorneys sit out for this one. They're benched. The court wants the parents to put their heads together. So they want those parents to alone meet with the mediator to try and reach an agreement about the kids. Now, they don't talk about money, so that court-ordered mediation related to custody and placement, they're not going to be negotiating issues of child support or anything else financial. It's just about the kids. Okay, so that's one version of mediation. Another one that is near and dear to my heart is what I call pro se mediation. What I mean by pro se is where the parties do not have attorneys. Okay, so in a divorce pro se setting, both parties are self represented. They do not have attorneys, and a mediator in that situation can be very helpful to work together with each party as a neutral to facilitate their divorce process. It's really important to understand in that context, right, where you have pro se parties working together with a mediator. For example, when I mediate these cases, I am an attorney. It's not like, that credential doesn't change. I'm still an attorney, but I'm serving as a mediator. So it's really important that my clients understand I am a neutral. I don't represent either one of you. I don't advocate for either one of you in this process. I can provide information. As an attorney mediator, I can do all of your drafting. So I can do legal drafting as an attorney mediator. I can even file those documents that I draft that the parties approve. I can file them with the court, which is a huge advantage, right? Because you have a legally skilled individual informing you of the process. I can explain what the laws in the state of Wisconsin are. I can even go as far as like helping to calculate child support and put together property division worksheets and balance sheets, help explain options and give the parties ideas for solutions. But at the end of the day, I'm not there to be an advocate. I don't give legal advice, right? And there's a gray line there, right, between advice and information. The way I would define that is a mediator should never be telling the parties what is in their best interest, is what's in the party's best interest. They shouldn't be saying, this is what I think you should do, or you shouldn't do that. That's not in your best interest. That's crossing a line. You need to be neutral. You're there to help the parties reach an agreement on their own accord. So just, it's becoming much more popular, this pro se mediation. So when I came out of law school, 17 plus years ago, I maybe saw 2-3 of these a year. Now I'm probably seeing 4 or 5 of these a month. For obvious reasons, I think it's picking up steam. People want efficient, low cost options, but still with solid results. And I think mediation for certain people, it's a really great option. Final mediation type that I want to mention is, and again, in a divorce setting, is when the parties do have attorneys. Okay, so we have both parties represented by counsel and they are stuck. They cannot reach an agreement. They have tried. Maybe this is financially situated. So perhaps they can't agree on maintenance, which means alimony, or maybe they can't agree on property division or who's going to keep the house. The parties can engage a neutral mediator to facilitate that mediation process with the support of their attorneys. So that party in that arrangement has an advocate in the mediation. So the parties each have their attorneys and a mediator. So we're talking 5 individuals participating, and that mediator will help to do some reality checking for parties who maybe are having unrealistic expectations. They might help to undig the heels. Sometimes we get stubborn and we get stuck in our positions, and hey, attorneys can sometimes also be stubborn and stuck in positions. So that mediator as a neutral can kind of get all the parties towards the center so that we can scoot in towards a middle area of resolution. So there's a wide range of mediation options. It's not a one size fits all. Certainly there's case types that aren't appropriate really for mediation. When I am screening individuals for whether they'd be a good candidate for mediation, I usually advise against mediation if there's a history of domestic violence, because in that situation we have a power imbalance, and having an equal playing ground for mediation is really important, especially if you're without an attorney. Another situation, an example, maybe if there's a history of severe dishonesty, if there's a baseline of mistrust, it's going to be very difficult, particularly, in the pro se mediation context. It will be very difficult for the parties to be able to rely on one another's statements if there's no trust there. So, I would say keep an open mind, think about whether mediation might be a good fit, because there's a lot of upside. It can save time, it can save money, it can keep the process low conflict, and it's private, and you're not airing out the dirty laundry in a courtroom. So hopefully this was enlightening about the mediation process and the different types that may be available in a divorce case. Thank you.
Mediation can save time and money, but But what if it doesn't work? When couples get stuck, most don't realize there's a strategic move that can push their case forward without blowing up things in court. So click to see the next step that actually works in Wisconsin divorces.